Hello, everyone, and welcome to this LexisNexis live chat on corporate insolvency. Thank you so much for joining us this afternoon for this panel discussion featuring industry-leading lawyers in the insolvency and restructuring space. A couple of quick housekeeping notes before we start. Please note that this webinar is being recorded and the recording will be made available to all attendees. Secondly, there will be time allocated at the end of the panel for audience questions. So please feel free to submit any questions you may have through the Q&A box, which you should see at the bottom of your screen. Now, I would like to introduce the moderator of today's panel discussion, Debby Lim. Debby has a broad commercial practice with overlapping strengths in banking and finance disputes, insolvency and restructuring, and domestic and international arbitration. Debby also recently authored the chapter on the Insolvency, Restructuring and Dissolution Act 2018 for the Annotated Laws of Singapore. So without further ado, over to you, Debby.
Thanks a lot, Roshni. Hi, everyone. Good afternoon. Our panelists for today are Mr. Lionel of Rajah and Tann, who is a widely recognized practitioner, and he has actually an active practice in major restructuring and insolvency work, banking, corporate, and commercial litigation, garnering regular accolades from both clients as well as fellow professionals and peers in the industry. We also have Mr. Nigel Pereira of Simmons and Simmons GWS. He advises on cross-border corporate operational and debt reorganization, insolvency, corporate investigations, as well as asset tracing and recovery. And last but not least, we have Ms. Teri Cheng, who's the director of Napier, and she specializes in insolvency and debt restructuring and advises debtors, creditors, and insolvency office holders on various transactional and litigation matters relating to insolvency and debt restructuring. So our three panelists today are the authors of the Woon's Corporations Law 2022 Des edition. So just to introduce the topics that our panelists will be speaking about today the order will be as follows. So first we have Teri, who will give us a general overview of the insolvency and restructuring regime in Singapore, and she'll give us a comparison of the key differences of the three regimes. And other than that, she'll also be talking about the practical considerations for companies when it comes to directors. This will be followed by Lionel, who will be covering the various issues that the court will consider in deciding whether to grant a judicial management order under the new IRDA regime. And our third panelist, Nigel, will cover a recent case that he acted in, which deals for the first time on what happens when there's a winding up application brought by a director. Back to you, Roshni. I think we can get Teri to start first. Thanks, Teri.
Yep, sure. Hi, good afternoon, everyone. And thank you, Debby, for the introduction. It's I think it's a pretty good time for a talk like that, given the rising interest rates and inflation that we haven't seen for a long time, supply chain issues, political instability. So all this potentially points to an increase in the restructurings and insolvencies moving forward. So we understand that the audience today is not just lawyers who practice this area of the law, but also a significant number of corporate counsel, company secretaries, or maybe people who are just potentially concerned about an increase in the number of insolvencies. So when sitting down to put together what to speak about, we thought it would be good to cover a broader spectrum of topics, and kicking off with some 101s on insolvency and restructuring for those who may not be as familiar with it. So in a nutshell, really, there are three main corporate insolvency regimes in Singapore. We're looking at liquidation, judicial management, and schemes of arrangement. So liquidation is when a company is wound up due to an inability to pay its debts. In this case, it's no longer a live company, and the easiest way to prove that a company can't pay its debts is to issue it a statutory demand. If the company fails to secure, compound, or provide security for the amounts demanded within a period of 3 weeks, the company is deemed insolvent. Another way to prove insolvency is to show that the company's current liabilities exceed its current assets. So what is current? We're looking at a period of 12 months. And this is known as the cash flow test. And the Court of Appeal recently in Sun Electric Power held that this is the sole and determinative test under Section 1252C of the IRDA. The Insolvency, Restructuring and Dissolution Act, which is the main piece of legislation we refer to. Once a company is liquidated, the liquidator then takes control of the affairs of the company, recovers its assets, and distributes it to the creditors in order of its priorities after adjudicating the proofs of debt. So the liquidator can also investigate into the affairs of the company and the earlier conduct of directors. So for counsel out there, corporate counsel out there who may think that their counterparties are going to go insolvent and have no chance of being rehabilitated, then perhaps placing that company into liquidation or commencing an application to place the company into liquidation is something you can consider. However, if you think that perhaps the company has a chance of being saved, then you're probably looking at either judicial management or schemes of arrangement. So let's deal with the judicial management or JM regime first. What happens is that first the company has to be or is likely to become unable to pay its debts. So that's the first. And the second is that there has to be a reasonable probability of rehabilitating the company as a going concern, or if the interests of the creditors will be better served in a JM rather than a winding up. Okay, so that's one way of saving a company. What happens when the company is placed in JM is that a third party gets appointed, and that third party JM will run the affairs of the company and puts together a plan to rehabilitate the company or increase the return for its stakeholders. Within the JM regime, a scheme of arrangement can also be proposed. So the question really is for many parties is why a JM as opposed to a scheme? So in the case of a JM, a third party comes in to run the affairs of the company. And this is useful if there is no more trust for the management of the company, right? And a third party has to come in to run the affairs and to also perhaps investigate into what happened in the past. Sometimes it may not be a trust issue or not so much trust, but they just think that the management cannot continue running the company due to incompetencies or whatnot, but the business is a good one. So then maybe this third party can come in. One thing to note though is that the traditional wisdom is that the JM regime is an expensive one because of the fees incurred by the JM to run the company and to put together this restructuring plan. So something to think about if your counterparty may be insolvent and you want to rehabilitate it, but that's a consideration for you because their fees do get paid in priority. The last regime I'll be speaking about is the scheme of arrangement. And in the scheme of arrangement, the insolvent company remains in possession of the company. So the directors still continue running the company, and generally with the help of financial and legal advisors, they will formulate a restructuring plan to improve the returns for the stakeholders. When a company is proposing a scheme of arrangement, generally one of the first things they do is to apply for moratorium protection from the courts. And the reason for this is really just so it can focus its energies on the restructuring without having to deal with creditor claims. Now, if you were to compare this to a JM, the reason why parties don't apply for JM moratorium protection is because once an application goes in for judicial management, there will be an automatic moratorium. So there's no need to apply again for the moratorium. So counterparties to potentially insolvent companies due to the moratorium or otherwise generally take a bit of a wait and see approach to see whether that plan is actually credible and worth their consideration. Right? But if they don't see real value in that restructuring or the company is just dragging the process out, they can apply to court for the moratorium to be lifted. What happens is that the moratorium usually comes in, say, 2-3 month periods. If the company requires further protection, they will apply again. If they fail to apply or the court does not grant the order for the moratorium, then the moratorium will lapse. But let's assume that this restructuring is going well and creditors are generally happy to hold their hands. The next step would be to put this restructuring plan to a vote. And if it is approved by the requisite number of creditors, then it can be implemented subsequently. And this requisite majority will be 75% in value and a majority in number of every class of creditors present and voting. So, I mean, there are quite a number of issues that could arise in a scheme of arrangement. Probably two of the most common ones would be one, whether a creditor is related, such that their votes should be discounted, and two, how the creditors of a company should be classed. And I thought it would be interesting to talk quickly about the case on DSG Asia Holdings, where the court in that case looked not just at the terms of the scheme when determining how creditors should be classed. The court there considered other factors outside of the scheme, right, and how that would affect the creditors in relation to that scheme in determining whether the creditors should be classed together. If there are any questions or we have a bit more time later, we can deal with that. But really the takeaway from that case is that while the classic test has and it remains that the creditor's rights should not be so dissimilar that they cannot sensibly consult with a view to their common interest, and that comparing their returns in the scheme to outside of the scheme, the court now does look at factors outside of that as well. So just keep that in mind when dealing with classification of creditors. So, well, given the time, I'll move on quickly to some issues which may be of concern to insolvent companies or when you're dealing with insolvent companies as a counterparty. Well, first and foremost, there are certain nuances to an insolvency regime, and that really, I think that the key really is that when a company is insolvent or on the cusp of insolvency, the duties will lie or be owed first and foremost to the creditors and not the shareholders, like a traditional healthy company, right? So that's the key. And given that the creditors' interests are at the forefront, the law then seeks to protect the creditors and prevent the dissipation of assets. So how can assets potentially be dissipated? A few things. First, well, the three main things that we see will be preferential payments, disposing of assets at an undervalue, as well as maybe insolvent trading. So these are the three questions that constantly arise when dealing with an insolvent company. So let's deal with insolvent trading first. What is it, right? It's defined in the IRDA under section 23912 and essentially occurs when a company continues contracting debt without the reasonable expectation of repayment. In circumstances like that, directors can potentially be personally liable. And this can be a challenge to the directors because they will wonder, okay, how do I continue business and continue to incur debt so that I can actually, rehabilitate, but I don't want to be caught by the insolvent trading regime. So some ways of dealing with it would potentially be to apply to court, right? For declaration that the debts incurred are not wrongfully trading. Or another way potentially would be to get a third-party financial advisor, which would probably have been appointed by then, to kind of look into those decisions and have an independent view as to whether those debts can be reasonably repaid. If that's the case, then there is a leg to stand on in the event any actions are brought in the future. The other issue I touched on earlier was unfair preference. And the overarching concern for that is whether one creditor gets paid in preference to another. And once again, if that's the case, directors can be potentially personally liable for that. And the creditor who is paid in preference may be required to return that sum of money, right? So there are considerations for both the directors and the company, as well as the creditors who receive the benefit of the payment. But of course, not all payments to creditors will constitute unfair preference. The payments have to be carried out within a certain time frame, and there also has to be that desire to prefer the creditor. if there was a proper commercial consideration driving that payment, for example, to continue the ongoing supply contracts with the counterparty, then that payment is unlikely to constitute unfair preference. The last issue I wanted to touch on was undervalued transactions, and say assets are being sold to raise capital for an insolvent company. When those sales occur, they really should be backed up, or rather they should be made for consideration which the asset is worth. So what the asset is worth could be backed by valuations or at least some proof that it's being sold at market value. Otherwise, if a transaction is one at an undervalue, then could once again be subject to clawback and directors could be personally liable. So just some key concerns that have arisen, as clients will ask and or concerned insolvent companies or counterparties may ask in this area. That's all I had. Debbie?
Yeah, thanks a lot, Teri. That was a very good introduction and sets the stage for the topics that we discussed by our next two speakers. So moving on to Lionel, he has an interesting live matter that he would like to talk about. And then I think it brings to the fore the questions of when the court will actually grant a JM order. So Lionel, I mean, subject to confidentiality and any sensitivity, I think just maybe you could share with us more about your case.
Okay, thanks, Debbie. And thanks, Teri, for the overview. It's a good starting point to talk about managing expectations of both the company and the creditors. So the case that I'm doing, which obviously is still ongoing, focuses very sharply on the disconnect between what the company hopes to achieve using the different regimes that are available under the IRDA and what creditors hope to achieve in terms of returns from a company that has got financial difficulties. So that is the context in which I would like to talk about when judicial management is appropriate and when a scheme of arrangement might be the way forward. Okay, so as a background, when creditors first are apprised that a company has got problems, apart from panicking and anxiety, the most commercial interest would be how much can I get back in terms of cents to a dollar. So that is a key concern for all situations where there's insolvency. And assuming the company is already insolvent, you have a couple of areas which the creditors will need to consider, either in conjunction with the company directors or independently, or with an independent financial advisor who may have been appointed by the company. So to start off with, a scheme of arrangement is appropriate where there's consensus and a common understanding between the creditors and the company as to what they hope to achieve jointly in terms of salvaging as good a position as possible from a very bad situation. And that is really a question of the company and the creditors working together jointly. In an ideal situation, there's trust, there's understanding, and everybody's working towards a common objective. But I touched on expectations at the start, which is the bugbear, the problem that always throws a spanner in the works. And expectations is this very unwieldy horse. What I expect as a creditor seems to be slightly different from what the company expects in terms of getting out of the situation and making returns to the creditors. So in a scheme of arrangement, the company actually remains in control under the board of directors, under the officers of the company. There is no third party that's appointed by the court. Teri touched on it when she mentioned the judicial management regime, and that's where an independent officer is appointed by the court. In a scheme of arrangement, it's consensual, and ideally, many companies do not wish to incur the potentially hefty cost of a JM application because judicial managers, as we all know, are not cheap. Okay, I'll touch on that later, but it is common wisdom that a judicial manager costs a lot simply because he or she has to learn the business, take business decisions, and run the company without the benefit of having run the company before. Anyone who's been involved in business will know that that is a monumental task. And when I say monumental, it means a lot of time, and a lot of time translates to a lot of money. So it is not that the judicial managers are just inherently expensive. It is because of the nature of their appointment that they are necessarily incurring a lot of time. And because time costs money, unfortunately, that is the way it goes. So judicial managers would really be almost like a last resort before liquidation. It's the halfway house between a consensual workout or scheme arrangement and the end game where the company is actually liquidated. So a judicial manager is kind of trying to see whether he or she can keep the company going. It's a very painful step, but there is a chance that the company could be rehabilitated, and that's what Teri touched on earlier. However, again, we come back to expectations. Creditors want their money back, and they want to get their money back with the least expense. So very often, it's difficult to persuade them that a judicial manager is the way ahead, right? Because there may be conditions perfect for the appointment of a judicial manager. For example, there are lucrative contracts in the pipeline. The company has got assets it can hive off. It's in a position to actually rehabilitate itself. And that's the essential crux behind a judicial management application, is to rehabilitate the company. But all this costs money, and so creditors will say, it's all well and good if you rehabilitate the company. How much do I actually get back after the judicial manager has been paid off? Teri already mentioned that they get paid first, and that's the way it is. They do get paid first. And lawyers' fees are also something that we all have to take into account. We like to say we're not expensive, but sadly, expectations are again slightly different. You can ask anybody else who's not a lawyer, and they will politely or less politely disagree with us when we say we're not that expensive. So we all have that problem. The expectations is always an issue. Creditors want to say, okay, I will do all these things, but I need to know how many cents to a dollar am I actually receiving. So if I don't go down the GM route, I work with the company, then shall we maybe get a better return to the dollar because we have not incurred the cost of a JM, and that would be a hefty savings in terms of money. Now, the short answer to that question is, do you trust the current board and officers of the company to do the right thing? And trust is, again, something that depends on both parties' expectations meeting somewhere halfway. The creditors may not really trust you because you have actually run the company to a position where it's insolvent. Having said that, you are the person or you are the board that probably knows the company best and knows what to do. So if you do the right thing, assuming you do everything legally, you should be able to get a better return for the creditor. But you will notice I used the word assume twice already. These are all dangerous assumptions. We cannot make such assumptions in real life because we are dealing with this creature called humans. The IRDA is fantastic in terms of provisions and the schemes and the regimes that are provided. But in reality, when we apply the IRDA provisions to real life and humans are involved, humans are complex creatures, as we all know. Unlike lawyers who try to be objective and analyze the situation, humans who have money at stake, humans who are trying to run the company, they are often beset by emotions and potentially irrational behavior and conduct. For example, selling off assets at a low value, hiving off assets to favorite parties, the sort of naughty things that Teri touched on earlier. These are done by officers who may or may not know better and are probably desperately trying to seek a way out of salvaging a situation. So you have a very deadly cocktail of humans who have different expectations, and whether or not they go with a JM or they go with a scheme of arrangement, very often the lines become blurred because you will also recall that under the JM regime, you can also put together a scheme of arrangement. Then the creditors will ask, why not we go down the JM route? Because you can still do a scheme of arrangement within the JM regime. But then they forget that, of course, the JMs are the ones running the company. It's no longer the board, it's no longer the officers of the company. That means cost. And cost, someone has to pay. It will be taken out of the assets in priority over the pool of assets left for the unsecured creditors. Okay, we're not even talking about secured creditors, we're talking about the unsecured creditors. And these are normally the ones with the most vocal objections, the most vocal queries and concerns, but they may not actually be owed the most. However, you still need their support. You cannot just put together a regime without taking into account the unsecured creditors, because they are a class of creditors that must support the company, whether it's by JM or whether it's by scheme of arrangement. In the JM, yes, it is something that the company or creditors can rush to court to apply for, but again, the court will always be mindful of what the creditors' concerns and interests are. As Teri mentioned earlier, creditors take priority over the company. Once a company is insolvent, the focus is on protecting creditors' interests, no longer the company. So creditors' support, whether it's for JM or for scheme of arrangement, is crucial for any successful restructuring to take place. And these were all issues that were highlighted and featured in the ongoing case. And it will keep coming back in any application which is contested, because you might put together an affidavit, an application that sets out perfectly cogent reasons for why a JM should be given or a scheme of arrangement should be put together. But equally, you will find other parties with different interests and expectations filing an affidavit that on the face of it seems very perfectly cogent and credible as well. So the court is often caught in a situation where it looks at conflicting evidence, conflicting affidavits that all make sense, and how does the court break the deadlock? That's where you have the creature called the accountant. The accountant, who is also not cheap, we all know. They also disagree that they're expensive because of the number of hours they spend to put together the scheme and the applications. But the point really is that the court will put quite great significance on an independent party's assessment and analysis of the situation. Because don't forget, creditors have their own vested interests. Company they also obviously have their own vested interests. So to break the deadlock, if an accountant comes on board and says, I think that this probably will work or will not work, the court will tend to put some significant weight on what this independent third party says. I know I don't have much time, so I just want to touch on the issue of cost. Now, we all know that a JM's costs are not cheap, liquidators' costs also not cheap, and this is something that corporate counsel and advisors will always be mindful of when they are being advised on the different routes to take. We have got the creature called an independent advisor, the IA. They can be appointed to look at the fees, review a cost schedule, and see whether or not that is fair or not fair. So that is something that creditors may sometimes want to consider, JMs may want to consider, appointing an independent firm of accountants to go over the costs that have been incurred, just to ensure that it's fair and it's reasonable. However, I want to end on this note to say that the IAs also cost money. Nothing is free in this world. So we all live in a world where nothing is free and costs are not cheap. Available funds are finite. I think Nigel, Teri, and Debby are very familiar with this situation. And the sad news is sometimes the lawyers, although we are supposed to rank in priority, we don't really get paid what we feel is fair. But I'm not going to complain. I'm just going to end on that sadly contemplative note and pass it on to Nigel. Thank you very much. Nigel, over
Thanks
to
a lot.
you.
Yeah, thanks a lot, Lionel. I think that was very engaging. And I'll take up some of it in the panel discussion later on. And I'm sure that people with questions, if you have any questions, please input them into the Q&A function. Nigel, you're going to talk about one of the very interesting recent cases that you handled. And in fact, this is the first time the court has considered this situation. Previously, prior to the IRDA, it wasn't possible for directors to commence winding up. It was just not possible. They didn't have the local standard to do that. So now under the IRDA, it's possible for them to do so. But in order for them to do that, they will need leave of court. So maybe you can take us through the case that you successfully handled, and maybe you can focus on the issue of what is the prima facie test that the court considered to be applicable. Yeah, thanks a lot, Nigel. Yeah.
Sure. Thanks, Debbie. Hi, everyone. Let me just start by saying Teri provided a very, very helpful overview of the restructuring and insolvency regime with some considerations, when a company heads towards that insolvency cliff. I like to call it the insolvency cliff. And Lionel helpfully touched on officers and directors of the company doing the right thing for a company and for the creditors by considering options like the JM regime or proposal for a scheme. Debbie, you're right. The IRDA introduced a number of new provisions which followed on from the reforms which were passed in 2017, which in turn had arisen from recommendations made by the two committees in 2013 and 2016. Now, one of the reforms, as you rightly pointed out, touched on the ability of a director to bring an application for a winding up order to be made against that director's company. You see, as Lionel pointed out, directors are at the helm. And one would really expect that they ought to know very well if a company is heading towards that insolvency cliff or it has simply fallen off that cliff. They also owe fiduciary duties, obligations to observe the pari passu and the anti-deprivation rules, and they need to be cautious to avoid wrongful trading. So with IRDA came the introduction of Section 1241B, which grants the local standby to a director to bring a winding up application, but this is subject to a requirement in Section 1242A for that director to obtain permission of court to bring that winding up application. Now, this provision, with most of the provisions of IRDA, came into force on 30th of July 2020. In September this year, the High Court considered the principles applicable to a director's application for such permission to bring a winding up application. The court observed that there would be occasions when a director's application would actually make sense. So for example, where shareholders and other directors have abandoned the company and where the local director is left all alone, subject to liabilities or potential liabilities for wrongful trading or failing to file statutory returns. But you see, there's a risk to all of this. The risk is that there may one day be a case where a director uses the application to bring pressure on the other directors or shareholders of the company to try and secure some kind of strategic advantage. This is a grave concern because obviously the procedure is not meant to be abused. So the provision incorporates a safeguard, a requirement for the director to obtain leave of court or permission of court to guard against this abuse. And to guard against this abuse, the court observed that they will consider a few things. First of all, whether there is a prima facie case for the company to be wound up. And Debbie, you asked that interesting question about what prima facie really means. The court observed that directors have actual notice, they have actual access to documents of the company, and they should very well know what's going on. So because of this, it's not just an appearance of a case that they ought to establish, but they should have enough evidence on affidavit, which on its own and without rebuttal would be sufficient to prove a case. That's the level of a prima facie case. The second thing which has to be established is whether the winding up application that's brought by the director is for a legitimate reason and not for some improper purpose. Now, in this regard, the court here referred to a few relevant considerations which arose in an Australian decision. So for example, if a director has no other means of bringing about the winding up, so the director was unable to find a way to voluntarily place the company in liquidation, then the application might actually demonstrate that the director's request for permission was not for an improper purpose. He had no choice. Or another consideration would be, is there a collateral purpose, in the application? If that's absent, then that would lean in favor of there being a proper purpose. Another point would be if any allegations of wrongdoing against the director were actually disclosed in the application, that can of course be raised with the liquidator, but that would also be an indicator of whether there's been full and frank disclosure by the director and whether the issues there can actually be dealt with by the liquidator. Then of course we look at the consequences of winding up if the orders are eventually made. We also would look at whether there's any genuine dispute existing between the directors and shareholders, because obviously if there were an improper purpose to bring the application as a pressure tactic, then the court would be on guard. And finally, the court also observed that there is generally a policy for insolvent companies to be wound up as quickly as possible, promptly, in appropriate circumstances, as a matter of public interest. So with all these considerations in mind, I think one of the advantages of this inclusion of this provision is to really allow directors in legitimate circumstances to do what is right. As Lionel was saying, it's important for officers to do what is right, and to put the company in liquidation so that the liquidators can then continue the administration for the benefit of creditors, as well as the other parties, employees, management, trade creditors, and so on. Debby, over to you.
So what kind of situations do you think this will apply? I mean, would it be like a situation where the nominee director is left, or independent director is left shouldering the burden, the executive directors have all, they're no longer contactable, things like that. Is that the sort of situation? Yeah.
Yeah, Debby, I think you're absolutely right there. It's probably going to be the situation where you do have the loan director, trying to figure out how to contact shareholders, how to get, a voluntary liquidation process in place, and all that's not possible. And then, of course, the director has no choice but to try and wind up the company and deal with his obligations. Yeah.
The problem actually would be if it's an independent director who's left in the lurch, as we know there are some cases where directors have all absconded. He doesn't always necessarily have full access to relevant information and documents. So for him to press the button and decide that he's going to liquidate the company, it's a pretty big step to take. And he's got to be sure of the consequences and know that it's going to be severe if he happens to have made the wrong choice. So whilst the provisions are there, I appreciate the reasons why they're there. In reality, again, may not be that common for a director in that situation to be able to press the button, so to speak. Yeah.
Yeah, right. That's certainly a different view. And there will be, of course, cases where the director might have absolutely no knowledge of what's going on. But conversely, it could also be a situation where because he has no idea of what's going on, it might actually be better for him to try and exit.
So we have a question from the audience. So they ask, what is the ballpark cost for such an application where an abandoned nominee director is faced, and has to take out this leave application to commence winding up? Any of you?
Well, I suppose in terms of the disbursements that you might incur, at least on that part, you're probably going to have to set aside a couple of thousand, for that sort of thing. And then, of course, in terms of the application that's brought, I think different cases would have come about from different circumstances. There'll be a question of what the director knows, how much information he has, whether it's going to be a long affidavit that you have to put in, whether it's going to be something straightforward. But as I said earlier, you have to establish the prima facie case for insolvency. So you must have evidence of the company's position. And then, of course, you also need to establish that it's a legitimate reason. And as a nominee director, there will probably be a few paragraphs of that at least.
I think the elephant in the room is always the director making a decision with legal advice, right? I don't see a director actually doing it without having sought legal advice. And it depends on the law firm and the lawyer involved, which would, to a great extent, determine the cost involved. So I think that is a bit difficult for us to put a ballpark figure.
Yeah.
Yeah, that's right. Any views on this, Teri? Yeah.
Yeah, no, as in I agree with both Nigel and Lionel. It really depends on the firm, depends on the extent of evidence that there is. Yeah, so it will be quite difficult, but Nigel's right, there will be disbursements, I mean, that will be incurred in not just in the director-led liquidation, but in even a creditor-led liquidation. The disbursements can be quite high because put in money to the OR, 10,000 plus, you advertise, so it does add up. So it's something to think about.
Yes, Teri, you're absolutely right, because it's a two-stage process, really. The first
correct,
stage
yeah.
being to obtain leave, and then the second stage is the actual winding up application. And we all know that the OR's deposit is already sizable. You've got advertisement
10,000,
costs
right?
and the
Yeah.
whole, and the whole thing.
But the money is from the company's funds, right? It's not from his own pocket.
I suppose it depends on how much the director really wants it.
Yeah, that's right.
Yeah.
Because that is a big determinant as to whether or not the director decides to do it or not, right?
Anyway, moving on to another topic that maybe we can discuss, right? I think both Teri and Lionel also touched on judicial management, right? So recently, I think Evin Tong, in his speech at the SICC talk, he mentioned something about how he wants to reform the GM regime. So, I mean, what are your thoughts on this? What other further reforms there can be? Yeah, bearing in mind that there's been really a series of reforms to liberalize and improve the GM regime, such as allowing voluntary GM applications where you don't have to apply to court. So what further reforms do you think the ministry is looking at, or could be considered?
Maybe I'll jump in first. And it's also tied to what Lionel said earlier. Yes, traditionally GMs are going to be expensive, not the most successful regime, right? So with that in mind, I guess the middle ground is really to have an independent financial advisor, right? If parties don't trust management to do the right thing, but management knows the business and they know the people, right? So the best of both worlds would probably be, in that case, to have an IFA, because they don't actually run the business. They kind of oversee it. Maybe they do monthly reportings to the creditors. So, they will cost something, but they probably will cost slightly less than the GM. Of course, that again depends on how much the creditors want them to step in. If the creditors want them to do weekly reportings, of course, it will, increase the cost. But usually, we're probably looking at monthly reportings to have an oversight on, if expenditure exceeds this amount, then they need the approval of the IFA and whatnot. So that's probably, to my mind, where it may move. Yeah.
Yeah, I agree with Teri. There's also the practical issue of what powers the IFA have, because in certain situations, the IFA can only do so much. And ultimately, the GM is here to stay, simply because the GM is a court officer and has got a whole slew of powers available to the GM. So I think the minister was much probably aware of the different considerations and needs of the different creatures that we're talking about. So it's really whatever fits the situation and which shoe fits best. And that's why I think he's touching on the need for some flexibility, less rigidity, and an ability to be open to hybrids and any other forms which would be less expensive, more nimble, and maybe where there's no real investigation needed, then maybe Teri's example would fit best, I think. So I think that's where we'll probably head towards.
Yeah, I think being nimble is the key. And so if the regime does allow more flexibility to consider options or to consider different routes to getting to rehabilitation, then that would certainly be better. I think in terms of managing costs, we already have the cost schedules which parties have to prepare. They can sometimes be quite extensive documents, in themselves. Just to have that submitted and to have that assessed by an independent assessor. So if provisions were introduced to somehow streamline that process, I think that would be quite welcome.
A question just came in, right? So they asked about whether lawyers have taken on insolvency appointments under the IRDA, and if not, what are the reasons? I guess you guys can also talk about what lawyers can do, even if they're licensed, right? It's not everything that they can do. Yeah. Any thoughts on it, like on this, Lionel or Teri?
I stick to what I know best. And I think I respect my accountant brethren who are probably better placed to do the right thing. I think there are issues of liability and responsibility, which opens a whole can of worms. So I'm very happy just providing legal advice. Even though I may be empowered to do other things, I would like to stick to what I know best. I'm just happy to be what I am.
I mean, if I were to jump in, I think as far as I'm aware, and anyone please let me know if I missed it out, but I don't think any lawyers have taken on insolvency appointments yet. Yeah, and maybe once again, conventional wisdom that we're not the best with numbers and we really shouldn't be put to run a company. So that's the first. But I think from a practical perspective, and I've realized that as well, I think that the accounting firms have a much stronger and larger junior team, and that really helps when it comes to running a company for JM in the least. They have more people to put on the ground, and that's actually quite helpful when it comes to putting in a team of people to run the company. Not so much lawyers, but something that Nigel, Lionel, Debby, should we consider?
I think the license only enables us to do the private trustee and MVLs. I don't think we can do CVLs, court audit winding ups and JMs, as far as I'm aware. Yeah.
Yeah, and I don't think we want to even open a further can of worms. So yeah, Teri's absolutely right. We are not the best people to be doing this.
I think one of the issues that we must always manage is the conflicts of interest that might arise. For example, if you were to do bankruptcy work, there's bound to be certain stakeholders in there which are financial institutions, and I think it's a life issue, for any office holder. Teri's absolutely right also about the resourcing. I can't imagine a bunch of associates running around getting a corporate insolvency matter done. So I mean, we're not licensed, or insolvency practitioners are not licensed if they're lawyers to do corporate insolvency, but it would require, I think, a fairly different setup from what we're typically used to.
Okay, one question I have is that, so now under the IRDA, it's quite clear that, you can have third-party funding for insolvency claims. So any views on that, and what are the safeguards you think that should be in place?
Yeah, I can start off with, because I'm dealing with one right now. Third-party funding, to put it in a nutshell, if they come in with money, they expect to be paid first. So that is the bottom line priorities, right? The problem is before that, whether or not they come in, and when they do come in, what happens? One of the practical issues is when they come in, they may have their own legal position and legal advisors. And if you are already the lawyers on board for the parties currently, they may keep you on board, but there's another set of lawyers who are also on board as lawyers for the funders. Sometimes you get replaced, sometimes you have to work with them. And again, it's something that not all parties are comfortable with, simply because two law firms may have the best of intentions. I'm not saying that there's any hidden agenda, but we may just have different views as to the best way forward. And very often it applies to cross-border asset tracing, where the assets are overseas. And from my own experience over the years, it is a very, shall we say, volatile cocktail in terms of getting assets back from certain jurisdictions. I think all of you will know that the jurisdictions are not the same as in Singapore. There are practical and judicial considerations to bear in mind. Certain countries recognize that facilitation payments are necessary. Certain countries view that as corruption. So to get money, sometimes you need to spend money. And we all have got different views on that. And for our firms to be involved in anything like that becomes very tricky. So sometimes the funders come in and they have their own lawyers, which is fine, and we drop out the picture. But they find that they are still facing the same historical jurisdiction issues when it comes to other countries that do not share the same jurisprudence as Singapore. I think you all know what I'm talking about lah. So cross-border asset tracing is a challenge, a huge challenge all of its own. And that always impacts on funding from third parties. Nigel, Teri?
Yeah, I was going to say that what's good about the new provisions is that there's a specific provision now where you can actually go to court and you can get approvals for funding agreements and the change in priority upfront, which actually puts to rest some of the concerns that funders have. For example, creditor funders, who might be prepared to advance a certain amount, but very concerned about whether they're going to recover anything, at least their expenses or priority and benefits.
Yeah, it's actually quite helpful because I recently did one matter where actually interestingly my counterparty was also my funding creditor. I mean, one of my funding creditors, and it was just all easily done, and the court just blessed it. So I think yes, they've taken away, like you said, some of the uncertainty, and it may make it more likely for maybe creditor funders to want to come forward now. But as for the third party funders, I think for them there's still an issue of they want to get their return. So, and then they're looking at quantum of at least US 10 million, right? So I think it's also not so easy for them to want to come on board. Yeah, even with the new regime.
Yeah, there are quite a number of claims that can arise which are well below $1 million mark.
Yeah, that's right.
Yeah, so that's a gap there.
Okay, we got a question from Ginny. How likely is the court to grant an annulment or stay of a winding up order? In the case of a nominee director winding up a company, there could be a chance that the director jumped on the decision too quickly. Although I think she reckons that the leave application is designed precisely to stop that from happening. Yeah, maybe I want to start with you, Nigel.
Yeah, so I mean, in a case where a nominee director seeks a winding up of a company, and it happens too quickly, I suppose someone must have stepped in at some point to say, I don't want the company wound up, and I actually want to keep it alive. So that of course brings up the question of solvency, and purpose, because in some cases you might very well just look at going to court to reverse the position. But in some other cases, you might actually look at what's taken place and perhaps negotiate with the liquidator to have a liquidation sale of assets, and set up a new entity.
I do recall there was a case about kind of like reversing winding up orders, but unfortunately I can't remember what the test is. I do recall that the threshold being pretty high. I don't think that case was discussed in the context of a nominee director winding up the company, but just generically if subsequently the winding up should be reversed or whatnot. Yeah, but unfortunately I don't have that, but I do recall the threshold being quite high. Yeah.
The IRDA actually provides for the ability to terminate a winding up order. So previously it was just a permanent stay, right? So
yeah,
I think those cases that the case that you probably had in mind was on that. I think there are a few, I think Interocean, quite a few, I think, yes. But I think the IRDA actually does say that you can actually terminate it rather than the artificial situation of having a permanent stay on the winding up order.
But I've always found that the question to really ask is, why would you want to do that? What's the end result that you're hoping to achieve?
Maybe they just want the company. I mean, it could be the former. I mean, the people behind the company or some of their related parties, right? So I think there'll always be some suspicion also, right? When you have this situation.
So perhaps what's good about the leave application that the director has to bring is that when the application is filed, I can expect that the application would have to be served on all the shareholders and all the directors to at least notify them that an order might be made, which could be adverse to, to the company and they're involved. So when they do get notice, and if they do have an objection to that, and they would very much like the winding up not to take place, then that's clearly the time for them to step up.
And there's always the situation where evidence or information comes to light after the order is made. So that's your situation there, I suppose, where you can reverse the order. Yeah.
Are there any more questions from the audience? If not, we are about 3 minutes away from the end time, and we're hoping to end on time. Or any last thoughts from the panelists? Like any key takeaways, or maybe you want to tell people why they should buy the book,
Yeah, with IRDA being fairly new, and with so many developments in case law, ever since July 2020, I think it's good to just have a resource to run to.